It's the argument by Judge Nelson that Trump's exercise of his Article 2 executive branch authority to call out the National Guard under Statute 12406, as he's done here, is beyond judicial review. The unelected, black-robed, tyrannical, inferior district trial court judges literally have no power here. They have no authority at all. Trump wins again in federal court, this time with the Ninth Circuit Court of Appeals. You may know the Ninth Circuit as being traditionally recognized as the most liberal of the federal court circuits. That's less true today than it has been in the past, but nevertheless, that's the reputation. And the Ninth Circuit Court of Appeals yesterday handed Trump a resounding victory, maybe a victory plus, on his authority to call out the National Guard, in particular, in the context of deploying it to war-ravaged Portland, Oregon. This was a 2-1 vote by a 3-judge Court of Appeals panel, and it tossed out the temporary restraining order issued against Trump by unelected, black-robed, tyrannical, inferior federal district trial court judge Karen, I'm not kidding, Karen McGirt. And this 3-judge panel, the majority opinion, cites reasoning error after reasoning error after reasoning error in Judge McGirt's estrogenically hysterical temporary restraining order against Trump. One of the 2 majority judges, Trump-appointed Judge Nelson, he wrote a concurrence that not only supports the reasonableness and lawfulness of Trump's deployment of the National Guard to Portland, Judge Nelson also argued strenuously that Trump's exercise, any president's exercise of this Article 2 authority, was simply not subject to judicial review at all, which is, of course, where we ultimately want to be. There was also a histrionic dissent by 76-year-old Judge Susan Graber, a Clinton appointee, class of 1997, when I was making the poor judgment to get into a horrific first marriage. So we're going to break down this decision. This is how it's going to work, folks, because it's pretty lengthy. It's 93 pages overall, and I'm not going to read 93 pages. But what I will do is I'm going to read the majority decision, the ruling in favor of Trump. That's about, 36 pages? That'll make up this main part of the show, the open access part of the show. We'll cover and break down that win for Trump and the legal reasoning behind it. Then, of course, we'll transition into the bonus show. The bonus show is for our members only. In the bonus show, arguably, it's the more powerful component of this decision, even though it doesn't carry precedential value. But it's the argument we want made before the Supreme Court, ultimately. It's the argument by Judge Nelson that Trump's exercise of his Article 2 executive branch authority to call out the National Guard under Statute 12406, as he's done here, is beyond judicial review. The unelected, black-robed, tyrannical, inferior district trial court judges literally have no power here. They have no authority at all. That is Judge Nelson's concurrence. That we're going to cover in the bonus show, which is the members-only part of the show. It's dirt cheap to become a member, folks. It's only 16 cents a day, $5 a month to be a member, and you get effectively double the number of shows. And really, you ought to be here for that. The concurrence, I think, is the part of this decision that I love the most. But we'll start with what is actually the win for Trump. So a judge has asked the larger panel of 29 judges to vote on whether to rehear this en banc. So if it's reheard en banc, it could be potentially reversed by the Ninth Circuit without getting to the Supreme Court directly. A judge of this court has sua sponte means on their own initiative, requested a vote on whether this case, this decision by this 3-judge panel, this victory for Trump, should be reheard en banc. The parties are requested to file briefs, arguments addressing whether this case should be reheard en banc by midnight, Wednesday, October 22nd. That's tomorrow. So this doesn't mean it will be heard en banc. In fact, just a couple weeks ago, maybe a month ago, there was a similar victory for Trump in the Ninth Circuit, and a similar request was made by an anonymous judge, Court of Appeals judge, to have that victory for Trump reheard en banc, and it It just disappeared off the radar screen, which generally means that the voting didn't go their way. So that's quite possible here. But I wanted to put this on the table because we're all in on transparency here on the Andrew Branca Show. Defendant appellants, that would be the great and powerful, democratically elected, Article 2 executive branch, Commander-in-Chief, President Donald J. Trump, Secretary of War, Secretary of Homeland Security, the wonderfully coiffed Kristi Noem, seek an emergency stay of the district court. That would be the district court, the unelected black robe tyrannical inferior district trial court judge Karen, I'm not kidding, Karen Immelgut. Her temporary restraining order issued October 4th, so a couple weeks ago, more than a couple weeks ago, enjoining President Trump order to federalize 200 members of the Oregon National Guard for 60 days to protect federal personnel and property at the Lindquist building, an ICE facility in Portland, Oregon, that of course has been under siege and attack for months. After considering the record at this preliminary stage, again, we're talking before the merits have been argued, right? It's a temporary restraining order has been issued. We conclude, the majority, the 2-1 majority here of the 3-judge panel, we conclude it is likely the president lawfully exercised his authority under 10 U.S.C. 124063 that allows paragraph 3, which authorizes the federalization of the National Guard when the president is unable with the regular forces to execute the laws of the United States. The evidence the president relied on reflects a colorable assessment of the facts and law within a range of honest judgment. Newsom v. Trump. So this was a previous, just a few weeks ago, Ninth Circuit Court of Appeals decision, a different 3-judge panel, but another 3-judge panel of the Ninth Circuit, just like this one, that had to deal with California Governor Gavin Newsom suing Trump and objecting to Trump's deployment of the California National Guard in LA to stop the riots there, protect federal personnel and property in LA. That Ninth Circuit Court opinion said, well, we have to defer to the president. We have to allow for him to call out the National Guard if his decision to do that reflects a colorable assessment of the facts and law within a range of honest judgment. In other words, we have to defer to the president's judgment on these issues. Now, importantly, that earlier Ninth Circuit decision, which this 3-judge panel says, the majority says, is binding on them. That's part of the majority opinion here. Now, Judge Nelson, in his concurrence, is going to say, I think the Ninth Circuit was wrong when they said they have a right to review Trump's calling out the National Guard at all. I think that was legal error. But if we're going to pretend that this is subject to judicial review, then Trump was still authorized to call out the National Guard because we have to defer to his judgment as long as there are colorable facts to support that call. So the Newsom decision here basically said, listen, if there were no facts at all, 0 facts, there was no rioting, there was no violence, there was no obstruction, nothing was happening on the ground, then we judges would have the authority to reject, to enjoin Trump's calling out the National Guard. So we do, the Ninth Circuit said in Newsom, we do have the authority to review the president's calling out of the National Guard, but we can only stop it if there would be no evidence to support it. If there's any evidence to support the president's judgment call, we have to defer to the president. That was Newsom. And to get to a majority in this decision, I guess the other Trump-appointed judge here in the majority said, well, I feel we have to apply the Newsom standard. So this is subject to judicial review, but I will agree the president can do it if there's any facts to support it. That's the legal standard the majority applies here. That's the legal standard from Newsom. In his concurrence, Judge Nelson is going to say, I agree with this result. I agree that Trump had the authority to call out the National Guard even under Newsom. But I also believe that Newsom is wrong in that it allows judicial review at all of the president's calling out of the National Guard. That's what we're going to cover in the bonus show. The members only part of the show is that concurrence. So we, the majority, conclude the defendants, Portland and the state of Oregon, the defendants are Trump, are likely to succeed on the merits of their appeal and that the other stay factors weigh in their favor. We grant Trump's motion for a stay tossing out the restraining order pending appeal. Now, pending appeal, the appeal, of course, means the appeal on the merits, the legal merits of the case, which really has to happen at the trial level too. That'll take months. It could take years to fully litigate. So the real question here on the ground has always been, during this period of months or years of litigation on the merits, during that period, will Trump be allowed to deploy the National Guard or not? The unelected black-robed tyrannical inferior district trial court judge Karen Immelgut said not. During those months or years of appeal, I'm going to restrain Trump from deploying the National Guard. This Court of Appeals is saying, nope, we're not doing that. We're throwing out that restraining order. And during the months and years of argument on the merits, Trump will be allowed to deploy the National Guard. Of course, he's only calling out the National Guard for 60 days. 60 days. So it all becomes rather moot on the merits anyway. Appellate jurisdiction. As an initial matter, the plaintiffs, that would be Portland and the state of Oregon, dispute whether we have jurisdiction even to hear this appeal because it was a temporary restraining order. And as we see, this is a trick that the unelected black-robed tyrannical inferior district trial courts like to use. If a court issues a durable preliminary injunction that would be in place for months, that's appealable to the Court of Appeals. But if they issue a temporary restraining order, that's normally not appealable. Why? Because it only lasts for 2 weeks. And the appellate courts say, listen, it'll take longer than 2 weeks for us to hear this case, to hear the appeal. So we're just not going to bother hearing appeals on TROs. We're going to refer to them as non-appealable because by the time we would get it, it would already be over. So what these feckless federal judges do is they issue a 2-week TRO, and then at the end of 2 weeks, they extend it for another 2 weeks, which they're allowed to do. Now they've obstructed Trump for a month. And only then, inevitably, do they transform it into a durable preliminary injunction that Trump can finally appeal. But what they get out of it, what these anti-Trump judges get out of it, is a full month of obstructing Trump with no prospect of Trump being able to appeal it to a higher court. And Trump has said, F that, I'm not doing that. You issue me a TRO that violates my Article 2 executive branch authority, I am going to appeal it, regardless of the technicalities. And the appellate courts have largely been saying, yeah, okay, we'll hear it. We'll hear it. If it's a TRO that walks like a preliminary injunction, talks like a preliminary injunction, we're going to treat it like a preliminary injunction, and we will hear it. And that's what happens here. As this majority on the Ninth Circuit Court of Appeals says, while TROs are normally unappealable, the Supreme Court has made clear that when a temporary restraining order has the practical effect of granting or denying an injunction, it should be treated as an injunction for appellate purposes. In similar circumstances, they don't really mean themselves, they mean a different 3-judge panel of the Ninth Circuit Court of Appeals. We recently held in Newsom that a TRO enjoining the president from deploying the National Guard to LA had the practical effect of a preliminary injunction. Therefore, issues of appellate jurisdiction did not affect the likelihood of success on the merits. We further explained that when determining whether a TRO should be construed as an appealable preliminary injunction, we consider whether things like an adversary hearing has been held, whether the court's basis for issuing the order was strongly challenged, because often a TRO is issued like that. It's an emergency. That's what a TRO is for. And so there's not been a lot of argument. And if there's not been a lot of argument, there's not a lot for an appellate court to look at. But where there has been a lot of argument, which would be expected before a durable preliminary injunction, when there has been a lot of argument, there is stuff for an appellate court to consider, well, then the TRO begins to look a lot more like a preliminary injunction that's appealable. We've also explained that when a temporary restraining order exceeds the presumptive duration of 14 days, so normally they're only good for 14 days, and then there's an option to extend it for another 14 days, which of course the anti-Trump judges always do. When an order exceeds the presumptive duration of 14 days, it is unlikely that it will still be considered a mere TRO and unappealable. Everyone agrees that the unelected black-robed tyrannical inferior district trial court judge Karen Immelgut held an adversary hearing and that the request for a TRO was fully briefed and argued, like a preliminary injunction would have been. But Oregon and Portland argue that the Newsom decision, the earlier decision from the Ninth Circuit, is distinguishable based on the duration of the TRO. There, the TRO did not automatically expire, and so could be enforced for more than 14 days, while here the TRO would expire 14 days after it was entered. But Judge Karen Emmelgut did in fact extend the TRO for another 14 days, so it would be enforced for more than the presumptive 14-day limit. Therefore, the TRO has a practical effect of being a preliminary injunction, and we have jurisdiction and will hear its appeal.